Welcome, Rahul.
My pleasure to be here.
Thanks for taking time out. By way of introduction, I have your bio in front of me, but I don't think I'm going to read it out. I'm just going to say founding partner Trilegal,
Yeah,
because I
that's
think
it.
that captures within it a remarkable institution builder. It captures within it work on in technology, media, telecom, and it captures within it someone who's actively engaged today with a lot of policy facing work. Rahul, before we begin, let me also say to all our fellows that I'm extremely grateful to you because you've been one of the earliest supporters of the fellowship and in particular of the technology law and policy pathway, giving me a lot of guidance on how to design a pathway that can be relevant, useful, and of course helps people start thinking about the technology question in a more insightful and critical manner. And of course, the fact that you are on our advisory board, been part of so many conversations, so we are extremely grateful to you for that. Rahul, this is just a conversation that we thought our fellows would benefit from, to have you here. There are a lot of concerns around careers and so on, and we will get to all of that later in the conversation. But let me just begin with a little bit of intrusiveness, there, breaching privacy, and just wanted to know how you really got into technology law back at a time when I'm sure these were not really part of our day-to-day imagination as students from NLS Bangalore and so on.
Yeah, no. First, thank you for having me. It's a pleasure to speak to all the fellows, I asked for this to be a conversation because I really don't know what to say if you just put me in front of a mic and have me speak. So thank you also for coming here and asking me these questions as opposed to having me speak about it. First of all, it's terribly embarrassing. I would never have said all the things that you've said about myself. But thank you anyway. And so it's sort of a good question to start with because I think if you think about it, at the time when I graduated from law school, which is going to date me horribly now, but since you're being intrusive, I might as well say it. I was the second batch that graduated out of the National Law School, which is the first sort of school of its kind at that time, which means I graduated in 1994. And in 1994, when I went went into my first job at a law firm called Dua Associates, there was one computer in the entire office. That was a computer that was next to the fax machine. It was connected to a modem that was blazing fast in those days. It went at 2,400 baud per second, which makes no sense because no one measures things in bauds these days. But it was really fast for us. And no one knew how to use it. I was the only one who sort of knew how to use it. And also, I was in Bangalore. So, to answer your question, these were the two things. One was a computer that I had access to after hours. And somehow I figured out that I could use that computer to access the internet. There was no internet in those days. The internet, I mean, there was internet, but you had to be in the Indian Institute of Science or one of the big institutions to have access to the internet, or you needed to be working for a company like Texas Instruments, and maybe Infosys at that time had the internet for a few select people, but no one else. There was no internet. And so the only way you could connect using that computer was to what we called in those days a bulletin board service. Essentially, it was a service where there was another person who had a computer connected to a modem, and you dialed into his modem using the telephone lines. And you only got through if no one else had actually currently dialed in. So if someone else had dialed in, you'll get a sort of a engaged tone, and you would have to keep trying until that person finished what he was doing and disconnected. And there was a etiquette in those days about, you get on, you quickly take off the information that you need, download it offline, and make way for other people to use the internet. Because that was all the internet. It was an asynchronous internet in those days. And so a combination of these two things, this bulletin board service would not have existed in any other city. Bangalore is filled with geeks, and even in those days, someone said, look, we'll cobble this together. And the fact that after hours I had access to this computer that the boss and no one else in the office knew how to use. And so I used it to get onto the internet in those days. And that was sort of the interest in technology. And very early on, I discovered that, technology law, and the area that all of you are interested in is certainly about law, but it is equally about technology. And you can't participate meaningfully in this area if you don't understand technology. And so, this was in about 94, 95 was when my technology journey started. And the first thing I do whenever I get into, answering a question for a client, or trying to figure out a policy or a new regulation, is to actually understand the technology underlying that regulation. And it's sometimes difficult because I'm not a technologist by training, but whether it is the internet technology, whether it is telecom technology, whether it is biotechnology, which means an understanding of the genes, you have to have an understanding of what the underlying technology is in order to be able to make any sense of what your clients want or what the regulator wants to do with it. And because I had this early start, and it was very much hands-on learning, you just pick up this bulletin board service and try and figure out how to make it work. And you don't know how to do it. You make mistakes, but then you read up, you ask someone, people will help you figure it out. And so that essentially was the way in which I got involved. And then and I'll answer all these questions one after the other. Is that in '94 I graduated from law school and joined Dua Associates. By '98 I knew that I didn't have a future in Dua Associates, just because I was ambitious. I wanted to become a partner, and I knew law firms in those days didn't make partners in the way that law firms today make partners. And so I said, I'm not going to stick around in a place where I don't think I'm going to make partner. There's a glass ceiling in a sense. And so in '98 I left to set up my own firm. In '98 I was alone. So that's April '98. By I think September, I sort of tied up with a classmate of mine, and who became my first partner. And then I'd always had this idea that if I could set up a firm in 3 cities, it's essentially 3x the acceleration of having it in one city. And I had friends both in Bombay as well as in Delhi. Reached out to them, spent some time, convincing them. This was a bold move for all of us, because none of us had law in our background. We had no godfathers in the legal system. And in those days, we were all used to working in big firms where we got these huge mandates. We knew we'd be working for small peanuts when you start. But we did it, and we set up Trilegal, and Trilegal was officially formed in 2000, and it's been 20 years, and it's been a good journey.
Yeah, this is the point where I say rest is history. And we hope that you write a book about just the founding of the firm and how the firm has evolved. I'm sure that that would be a very important and interesting learning, for many of us here. In fact, a lot of trilegal's, inception growth sort of coincided with the opening up of the telecom sector in many ways, right? So you have seen regulation happen both at the pipe end and, of course, now at the platform end, but I'll come to that soon. So at the pipe end, how did this whole thing happen, right? The telecom sector liberalization, but at the same time, we continue with this 1885 enactment. I mean, there is a lot of anachronism there. So could you sort of share your thoughts about how the sector has been regulated and how you've seen that sort of evolve?
Yeah. So, and maybe I'll share some personal experiences also, because the firm has been involved in some reasonably significant events along the time. But just to the point on how the sector is regulated. I mean, look, when we first liberalized the telecom sector, we were essentially liberalizing it because the government's push, and the government had made many attempts to push telecom into the country. They had CDAC and CDOT and all of these various government initiatives that were, if we go back into that past, they were focusing on manufacturing. So there was a big push on actually manufacturing telephones and even switches, electronic switches in the country. But despite all the efforts of the government, that was just not working. And so this new technology came out, which is cellular technology. And I think the government realized that at that point in time, they were not going to be able to roll this out because, one, it required investment. It required a whole different sort of investment because you needed to put up towers. The government's previous approach was to actually lay copper to each person's home. And you may not remember it, but when I was growing up, in order to get a telephone connection in Bombay, as it then was, when I was a student in school, it took you a year and a half. And then once you got the telephone connection in Bombay, you wouldn't move your house because the new house you move to may not have a telephone, and you have to wait for another year and a half for a phone, right? And so that was the reality of it, and that's because last mile, what we call last mile connectivity, is a huge challenge. You actually have to lay the copper all the way to a person's house, and that was a non-trivial sort of an act. And so the government realized that when this new technology came, they needed to try another method. And so that's how the liberalization happened. And I remember that, obviously, the metros, Mumbai, Delhi, Calcutta, and Chennai got the first round. And so Bangalore, where I was, we didn't have a mobile phone connection until the second round of licenses. And in the second round, it just coincided with me setting up the firm around about 98. So this was a big leap. I didn't buy a landline connection for my new firm. I only had a mobile connection. Now, mobile connections in those days cost 16 rupees a minute. The entire cost was borne by the recipient. Regardless of whether I made the call or I received the call, I would have to pay for that. There were all sorts of issues along the way. The government, the BSNL and MTNL refused to terminate the calls because they were like, look, why should we terminate the calls of this person who's going to eat our lunch? And so there were issues along the way. Now, why did we actually go this path and not create a brand new law for this? I don't know. And this is part of some of the thinking that I've done just on the way in which we work out policy in this country. We tend to find the most appropriate bucket into which we can put a new technology. And if that bucket exists, we don't take the effort to actually create a new regulation. We just find a way in which we can force this new technology into the old bucket, which is why the modern internet and all the remarkable things that we do on the modern internet is regulated by this act, which was written by the British in order to regulate the transmission of messages using current over a wire. And the reason why it still accurately regulates it is because of the definition of the telegraph, which essentially talks about electromagnetic waves running through a medium. Now, even if you think about the computer in some atomic way, there is an electromagnetic wave running through the circuit board, and so arguably the Telegraph Act can continue to regulate the internet. But that, and the point is that it didn't exist when the act was enacted. So how can it regulate? But this is it. We find a bucket, we find a pigeonhole, we shove things into it, and we keep it there. And then we have to put up with the cascading consequences of that initial first decision. Because there are so many challenges right now. I mean, one challenge is this license-based regime, right? So in order to enforce any of the provisions, you have to enforce the license, which means that people who are not licensed entities are not regulated by telecom law, if you actually think about it. And why is this meaningful? Is because WhatsApp and all the OTT players, people who are providing services over the top of telecom services, are not regulated. And so the telecom department finds it very hard to impose regulations on all of these entities. And if you think back, that original decision is because we didn't have a law. Because if we had a law which governed the transmission of messages over the internet, I'm just making it up, but if we had a law like that, it would govern that whether it's been done by Airtel or whether it's being done by Facebook. And that the reason why we have many of the problems we have today is because of that initial design choice of trying to go down this license route as opposed to creating a regulation. And it surprises me even today that we don't take the effort to actually go out and make a new law. That over the years in my career, we've had the convergence bill, which died a natural death. We've had many attempts to amend the broadcast regulations, the telecom regulations. None of them have fructified.
Right. But another part of the story, and that is, I guess, the success in many ways of telecom regulation, is the way that pricing from that 16 rupees, a minute has come down to whatever it is today, and there are a lot of regulatory choices, I guess, which go into that evolution and how the market has become that way. Could you elaborate a little bit about what?
So I think the first thing was, look, we started out, and I don't know if this is by accident or by design, and just to be charitable, I'm going to say it's by design, but we started out saying that we are going to ensure competition. So no one was going to be allowed to have a pan-India license. You were given licenses in certain areas, and as I said in the beginning, it was the 4 metros, and then slowly it went out to the whole country, but you couldn't have a pan-India license in the first round, which means there were a multiplicity of players. And then as a result of having a multiplicity of players, we could roll out this network much faster than any one player would have. Because if you had one player, that player would have focused on the most lucrative circles, which would have been the metros, and no one would have done anything anywhere else in the country. But by actually doing this, we forced the rollout. The second thing that we did was we had an obligation to cover a certain area, and so there was it was part of the license which says that you must cover this amount of territory within this amount of time, and then the entire area within another amount of time, and then there were incentives, which is that as you cover this, we will give you more and more spectrum. That was the original construct, and so what happened was that we had a lot of very quickly we rolled out this network over pretty much the entire country. And then the other thing they did was they kept auctioning out newer and newer licenses. And so we had 3 or 4 rounds of license auction before we had any big upgrade in technology. And so the big upgrade in technology is when the 3G network comes out. But well before that, we had this rollout mandate. And in the rollout mandate, there were also restrictions on M&A, which meant that you were forcing people to actually grow their business by acquiring new customers, as opposed to acquiring another entity that had acquired customers. All of these are very important strategic choices that we made. I think the negative in this context really is the license fee. And in the original structure, we actually said you must bid for a circle, and then you bid on the basis of what we project is the amount of customers that you will get in the circle, and then you have to pay us the license fee. Now, that's how the first mechanism was set up before the current regime that we have, and they realized that the government's projections of subscribers were far off the base, and so they were paying a license fee on a number of subscribers that was significantly higher than the number of actual subscribers they had. And so there was a time when Bharti Airtel virtually was within a few months of going bankrupt, when the government then changed to the revenue share. So now the other significant thing is this revenue share model, right? Because the revenue share model actually is a very growth-oriented approach to telecom, by saying that we will allow you to grow, and we will only take a percentage. Your license fee will only be a percentage of the revenue that you actually make. These are sort of very growth-oriented. And at roughly the same time, there was the opportunity to do M&A. By this time, the entire country was covered, maybe not covered in depth, but covered. And so there was the opportunity to do M&A, the opportunity to invite new players from outside. So the firm, so some of the things that the firm did was we first assisted Reliance Infocom. That's not the Jio. That's Anil Ambani's company. Though at that time it was Dhirubhai Ambani's company, because Dhirubhai Ambani was still there. And we helped roll out Reliance Infocom, which gave us a good understanding of exactly what it takes to roll out a network. See, we'd understood how the technology works, but when you actually go on the ground, you realize, every tower needs a generator and it needs security. These are the sorts of things you don't think about because the technology doesn't speak about it. But you need in India a generator. Because otherwise, if the tower goes down, then there's one cell which is not firing in the network. And then we learned about what's the network. How do we create a network such that there's optimal coverage? These are all sorts of things you only learn on the ground. So we first helped Reliance roll out their network, and then when Vodafone came in, we helped Vodafone acquire the Hutchison equity in Hutchison Max, which was a big player in those days, and so we helped Vodafone do that. And when that happened, there was the next really important development in telecom, which is sharing. And so, in the beginning, you had to roll out your own network, you had to roll out your own towers, etc. But round about the time when Vodafone came in, there was a big change, which said that we are going to allow you to share infrastructure. This is another huge liberation because if you can share the infrastructure, one, it's more efficient to share infrastructure because on a single telecom tower, you can actually put three, up to three, maybe with new technology, 4 or 5, transmitting stations without overlap in bandwidth. See, when you put many transmitting stations on the same tower, adjacent bandwidth will tend to reduce the quality of the network. But the optimum that they figured out at that time was 3, which meant that you could get 3x the revenue on your tower. And also it meant that you could get 3x the coverage that you had before. So that's another element that brought the prices down. And towards the end, another company that we advised coming in was Telenor. Telenor didn't put up a single tower. Telenor rented all its towers, and all they did was put up the radio equipment, which is just that one thing on the tower that was transmitting. So these are the elements by which over the years the government has, as I said, by design or by accident, introduced measures that have made it more and more efficient to provide the service. And of course, we are a country that just loves using these services, and so we just absorbed it all. And as more and more people come onto the network, the economics of it bring the prices down to the point where we are currently enjoying the cheapest tariffs anywhere in the world. And then once Geo came in, which flipped the whole story and said we're going to go data first, we are now enjoying the cheapest data tariffs anywhere in the world. And still, we have so much headroom to grow, given that we at this point in time have maybe about 450 million to 500 million smartphones in the country, and we've got a population of 1.3 billion, which means that we have more customers that we can acquire than we actually do have, which is a remarkable situation given the costs at which these services are being provided.
Rahul, I think it's amazing to just hear you speak how the whole trajectory has played out in this sector, and it's also interesting that you end it with the data uh, disruption in some sense, right? Uh, it has raised a lot of questions from a regulatory point of view. Uh, First, there is, I think, the data protection set of questions, but keeping that aside for a moment, there's a huge competition set of questions that have come up. And in particular, just over the last 3 to 4 months, we've seen massive acquisition of stakes by data creators in the pipe, which is Reliance Jio, and it's the pipe in the Indian context because we have seen a massive erosion of competition over the last year or two. So, how do you really see this space kind of evolve? And from a policy point of view, considering that none of us want to be at the mercy of one particular entity, right, which is providing us connectivity and which in many ways is converging with content providers. How do we sort of think through this imbroglio?
Yeah, look, I mean, I heard also before we started our talk some questions on competition, and look, the competition question for me is a difficult one because as much as I am concerned about the adverse effects of competition, if you go through the history of competition, you find that one of the fears that highly competitive or anti-competitive entities have is that, or one of the assurances they have is that they will not be disrupted. But one of the fears they also have is that just in the same way as they disrupted the I guess the monopolistic entity that came before them, they can also be similarly disrupted. Now, the risk of this, of course, is that when you talk about the pipe, that's sort of the core infrastructure, and that seems to be, holding the sort of the core of the problem in your hands, and we think that we can never disrupt an entity that does that. But look, I mean, I think that there will certainly be a natural evolution toward away from this concern that we have. The way I see this world developing is I think that we're going to develop into carriers, people that actually provide the infrastructure, and the people who provide the technology on top of the carriers. And certainly we can have a monopoly entity that controls the pipes, but you are going to have differentiated entities on top of those pipes that will provide additional services that could potentially be way more important than the actual pipe. So to me, I think a lot of the competition focus should be on top of the pipe, because increasingly the pipe is becoming less and less differentiated. There's, once you're getting speeds that are in the 5G level, right? There's really is very little you can differentiate as far as the pipe is concerned in terms of the service. And at some point in time, we're going to re-rate broadband to say that broadband is, one GBP, or 1 Tbps, or whatever the new level is, where you don't talk about buffering. I started out saying 24 baud per second is the speed at which I used to get internet in my modem. You will just not put up with it, given what we're used to right now. And so it's going to get to a point where that data and the speed at which the information comes to you is going to be relevant, because it is going to be faster than any service that you use. 5K video will stream without buffering, and you will be able to do sort of augmented reality type processing on the fly in your headset. Once that happens, even Geo is not going to be concerned about owning the pipe, because they will be forced down to provide the services they provide at the cheapest possible rate that they can, largely because all the services and all the value is on the layer above. So my concern right now is on the layer above.
Right.
And of course, there is a concern that the layer above can also be captured by the person with the pipe, and that also is happening. There can be certain challenges with that, but the focus, I think, is more at that level to me. And the good thing about that level is that at its core, that level is all data, which means whether the data is on Facebook, whether the data is on Google, whether the data is on whatever the Geo app is, it's data. And it is possible to control data from a regulatory perspective as well as from a design choice perspective. And there are some really incredible things that are happening in India on unbundling that data, unbundling it from scratch in a way that at the core level, we are defeating even the possibility of someone creating a monopolistic layer. We're doing it in the financial services sector, and most recently we're doing it in the healthcare sector, and those are really interesting developments that is unique in India.
Right. And that brings me to your book, Privacy 3.0, because there you recommend a very different way to start thinking about regulating players who are innovating on this over the top space, whether it's content, health tech, or any vertical. And what are your thoughts on how the government is currently going about regulating data, particularly in the data protection context, both personal and non-personal?
Yeah, so look, I mean, the book talks proposes what at the time was fairly radical, but now is increasingly becoming a little more acceptable approach to privacy. So privacy, as you know, around the world is largely regulated on the basis of consent. So consent forms the primary basis for regulating privacy. And the reason why this happened is, you go back to the 80s. There was the Fair Information Practices regulations that were issued in the US that got recorded in the OECD regulations on data. The OECD regulations got recorded in the database directive in Europe, which most recently has got sort of expanded into the GDPR, which is the General Data Protection Regulation in Europe. And there's a California Act. Most laws around the world are now using GDPR as a standard, because in order to interact with Europe, you need to interact on the same basis as the GDPR does. So in many ways, what started in the 80s as a consent-based framework has evolved now to this hyper consent-based framework, where you need notice for pretty much every sort of data collection that you do, and things like that. And in the book, I question this, and I say that, look, in the current context, with data being generated in such prolific form, across so many surfaces, it is completely impossible to collect consent in the way that we were able to collect it in 1984, right? And the point that I make is, just take some examples of Internet of Things devices. If you have an Alexa device, or if you have a smart assistant on your phone, it's listening to you all the time. And when I say it's listening to you all the time, you consented to it because you bought the device, and in order to start for you to start, it needs your consent. But you have visitors who come into your home who haven't consented to it, right? But they still collect that visitor's voice, because they need to distinguish that voice from yours. Now, all these devices say we'll do it in a manner which ensures what they call differential privacy, such that we do the evaluation on the device, and it doesn't go out. But how do you figure this out? And then you've got these smart devices, smart refrigerators. All of these are collecting information about you. You've signed up to all those privacy policies, but there is no way you can know what that is being used for down the line, because there is just no way in which you can figure out all the uses of that data, right? So for all these reasons, I say that it is actually very difficult for us to use consent anymore in the modern paradigm. So the book argues for an accountability framework. And what this means is, let people collect the data, because there is no way we can stop it. At this point in time, that genie is out of the bottle. But make them accountable for all the harms that result from the use of the data. The second thing that this model addresses is the fact that we are subject to a tremendous data asymmetry. We are providing the data. That data is so-called valuable. We say data is the new oil, and I hate that framing, because it has connotations which are really pernicious when you start using it. But data is valuable, but then the value of the data is not visible to anyone other than the data controller, because the fact of the matter is, data is only valuable in aggregate. So you can only give your little tidbit of data, and that little tidbit of data you think is greatly valuable, but actually it's not valuable unless Facebook puts it together with all the other people whose data it collects and makes it into something which is capable of predicting how humans will react when they are shopping, or whatever else it is. So there is an asymmetry, because in order to decide whether a particular consent that you provide to Facebook is going to harm you or not, you just don't have the information you need to make that decision, because it is Facebook who has all the information of all the other things that they are holding with them. That will determine what it will be used for, and when it is used, what the consequences are. So the accountability framework is a mechanism to address this asymmetry. Essentially, what we are saying is, the user, or the data principal in the PDP bill framework, is someone who doesn't know what that consent, the implications of that consent. But the data collector that has all of this information, has accumulated all of this information, that data collector certainly does know. And then, if knowing what consequences could result from the use of this aggregate data, they still go ahead and use it, and that use causes some harm, they should be held accountable. So that essentially is the framing. I'm finding, just as I'm reading more about this, that this is a framing that seems to be resonating with more and more people around the world. The EU is considering accountability. Now, under the EU GDPR, there is an accountability provision.
Yes.
So that accountability provision essentially says, do the training, tell all your people what the consequences are, and that's it. It's not linked to harm. And the reason why it's not linked to harm is because this is pretty dangerous. I mean, the what is harm? How do we decide what is harm? If I'm denied a loan, it has harmed me. But if I was not entitled to the loan because I didn't have the wherewithal to repay the loan, how can you expect someone to give me a loan? And how can you call that harm? So these are the nuances that we've got to work out. But at the end of the day, I can see no other way in which we can reasonably deal with the amount of data that's being collected. We certainly can't use consent is sort of the way I think about it. And recently in the US, there are a few senators that are looking at coming up with accountability-based laws. I know the EU is also considering some of these things in a little more detail. We'll need to see, but this is sort of the way I think that this law is going to develop.
Right. Rahul, as ever, and there are many more things I want to ask you about e-commerce, about your podcast. I mean, so many things. But the students. So this is a situation where I would like our students to start interacting. There are some questions that have come to me privately, but I would just request you all to just unmute yourself and have a conversation. I mean, he's here for the next 20 minutes.
Sure. No, happy to speak to.
Yeah, hi. Can I go first?
Sure.
Yeah. Hi,
Rajat?
sir. This is Dhruv this side.
Dhruv, yeah.
Yeah. So I had two questions. One was from a business perspective. How relevant do you think is location an issue in terms of setting a TMT-based practice as of today? And the second question is with respect to the framework that you talk about, the accountability framework, is there any conceptual overlap with Dr. Helen Nissenbaum's contextual integrity framework in terms of the way you devised it?
So, Nissenbaum. So first of all, I'm not the first person to say that consent is broken. So there's a lot of literature on the problems with consent. I don't think anyone has gone as far as to. And I'm familiar with the contextual integrity framework. I don't think it goes as far as I go with regard to harms. So to the extent that Nissenbaum's work actually pulls out a lot of the challenges with consent, there is a lot of overlap. But there are many framings that, in a sense, invert or try to address the data asymmetry challenge. Nissenbaum's is one of them. Solov has got his own interpretation. There is, I can't remember his name now, there's someone who has looked to invert the sort of the customer relationship management approach to make it a vendor relationship management, to essentially flip it to say that the user is responsible for what it gives to vendors, and then it creates an app-based mechanism by which it shares data to other people. Tim Berners-Lee has come up with the Solid project, which essentially is looking to find a way in which you have much more control over your data. I find all of these challenging to implement, largely because one of the things that I said, right, that the value of the data is not in what the user does. It's actually in the aggregation of that data. If we can't allow the data to be freely aggregated by companies like Facebook and Google, we will never unlock the value of the data that we have. So if you are creating restrictions from the user's side, so if users are going to decide how that will be collected, I don't think that that is going to unlock the value. It's just going to impair innovation. So I want to allow innovation to take place, which is allow Facebook to do whatever they want with the data. But if they harm me, I want to have a way in which to have a stick against them. And then on the second point on where we should build a technology practice, I mean, anywhere in the country. Look, it helps to be in a place where you can actually sit with technologists. But I'm increasingly finding that I can't make policy out of Bangalore. I have to go to Delhi to make policy. So you have to be in both Delhi and in Bangalore to do policy. And there's technology everywhere. But it's really good to be at a place where you are at the cutting edge of technology, so that even just in your conversations when you go out for a beer in the evening, you're talking technology and you're understanding, what exactly is happening. I just feel in my particular practice that it's important for me to also be in front of regulators and to explain it to them, which means if you want to be in this particular area, which is technology policy, you're going to need to find a way to be in Delhi as well.
Ishita, would you like to go next?
Yes, sir. Can you hear me?
Yep.
Yes.
I'm not switching on my camera because there's some internet problem. So, sir, thank you, Rahul Matthan, sir. Like, it was really good understanding the conflict that we are currently facing. But my question is more to do with something that you talked about just now while addressing Dhruv's question as well with respect to the use of the data versus the collection of the data. And from my current understanding is that most of the onus isn't really placed on the user. It's more like that the companies currently have sort of the responsibility to let the user know what they're doing with the data.
Right.
But even if we delineate the harm and the companies outright don't tell us that what they're going to do with us, and it's much easier for them to get away with the harm or find ways to sort of show people that they're not doing any harm unless and until they like tell have any responsibility to tell the user what they're doing with it. So even if I'm consenting to it without really knowing, or allowing Facebook to collect my data without really knowing what they can do with it or the list of activities that they can undertake with it, uh, I don't know, it just seems to me that it might be difficult later on to deal with any kind of harm that might come forward, because as you've just said, it's progressing day by day. So because regulators aren't really able to catch up, or the general public isn't able to catch up, how do we then able to hold Facebook accountable, because we've given them their data and we didn't really know back then what they were going to do with it. And
Yeah, look,
also,
I mean,
just to okay, sorry, can I just like complete?
sure.
There's a second part to this question that I think we've talked a lot about how there should be regulation, both in terms of like laws and statutes, and also in terms of policy. But like you said, that the economics of, especially in the tech sector, are a very big markers to how and in which direction the entire industry is moving. So do you think that there should be, and what kind of economic incentives or disincentives should be there in place, at least in India, to stop companies from either collecting our data en masse or undertaking certain activities with the data, or selling off the data to third parties? That
Yeah.
is my question. Like,
Okay. And I may not remember all the points that you said, so feel free to just remind me. But here's sort of the high level, right? I think certainly there are a lot of harms, and there's a lot of I guess malpractice that's happening with data. But at the same time, there's a tremendous amount of good that's coming out of data. And really, the challenge that we have is to find a way in which to balance these two. So for every example that you give me of some entity, I'm not going to name Facebook or Google or any of these entities, but any entity taking data and using it for maybe just selfishly for their own profit, or even in a harmful way, as in selling it for spam, etc. I can tell you maybe an equal number, if not more, of instances where the fact that we have data has allowed us to make inferences that would otherwise have never been possible, and as a result have saved lives. And there's a simple example. I can't remember the names of the drugs, but if you look at Matt Ridley's book recently, How Innovation Happens, he talks about two drugs. One drug, both of which are FDA approved, and these drugs are perfectly fine. But if you take those drugs together, you will have such serious blood sugar problems that you can instantly become diabetic. Now, no one, and there's nothing wrong with the FDA approval, because the FDA approval is actually allowed for this to happen, given that they thought about the drug in its singular context. But when you put the information together, you realize that there is this really harmful effect. And how do we discover this? Essentially, someone went and looked at diabetes and did a sort of a data search to see where are the instances where people have diabetes where two drugs were prescribed together. There's no way you can get this information unless people are collecting data And this is essentially like a Google search. You're saying, what are people searching on Google? When are they saying they've got a headache? They say they've got a headache when they've taken these 2 drugs. So using data, they've actually been able to find information that, but for this data, would not have been possible. So to answer your question, Ishita, if I was going to restrict the collection only for a singular purpose, then I would never be able to find these lateral uses of data. So today, the real benefit of data is that we don't know what it will be useful for at a later point in time. Think about Google Photographs, right? Google allowed you a place on which to store your photographs. You stored your photographs, and they then allowed you to tag yourself in the photograph, or just to describe the photograph. What did they do? Essentially, they created, crowdsourced, a huge annotated image library that they could then use their algorithms to do image recognition on. As a result of the image recognition technology that they developed using that, we have some tremendous features today. We equally have really harmful features. I'll tell you all the harmful features. Today, an autonomous drone, which is armed, can actually use the same sort of Google recognition technology to target a militant or maybe an innocent person and shoot him out of the sky, right? And that's sort of the harmful part of the image recognition. But there's tremendous good in image recognition, because today image recognition technology, when it's applied to radiology scans, can identify cancer tumors in a way that no human eye can. At this point in time, the image recognition capabilities of AI far exceeds the diagnostic capabilities of human radiologists. So these are the sorts of trade-offs that we are constantly having to deal with. Now, I don't know whether prescribing a purpose is going to get us there, because quite frankly, my experience of consent and all the privacy policies, I always ask this question. All of you are lawyers or aspiring law students. Tell me, have you read all the privacy policies on your phone? Anyone put their hand up? I mean, do the thumbs up thing if you've read, right? I mean, I make my money on privacy. I've been doing privacy for 15 years. I haven't read all the privacy policies in my phone, and yet I've accepted them. Right, so I could have said on the night of the full moon, you will sacrifice your firstborn in the privacy policy, and I would have agreed to it. Who knows? It may still be there. There are people who put this in as a prank, right? And so that's the point I'm trying to make with consent. It's currently meaningless. And if it is meaningless, can we find another way to work? Now, accountability is not the best solution, but I'm trying to find, there's another beautiful solution, and that is granular, just-in-time consent. And I can talk about that when we talk about the DAPA framework if you want, but that is probably a way to go. But then you have consent fatigue and all of those things. So as I said, Ishita, I don't know if I'm going to answer your question, but I went about it slightly at another angle, just to give you another perspective on this.
Ruben?
Hello. Yes, sir. Good afternoon, Rahul, sir.
Good afternoon.
It was a pleasure listening to you, sir. Sir, I have a few questions. I'll put it forth. So, firstly, with regard
Actually,
to
you just ask me one question, because as you can see, when you ask me a question, I speak for like literally hours. So if I have one question, I'll try and keep it short and give more people the ability to answer.
All right.
People can then.
Okay. The first question I shall put it forth. So, with my question is with respect to upcoming trend of self-regulation that's coming up in all these many companies. So, in these e-commerce companies, also recently the Competition Commission of India released an e-commerce report where they also propose the idea that they go for self-regulation. And recently, Netflix and a lot of many companies came together under a society, and they started to self-regulate. So how do you think this is going to change the landscape of all these companies? Is that the future, and the legal implications of it, whether it's we can legally impose it later on? So that's my question.
So that's a great question. Look, I have written at great length on the fact that one of the problems with technology is that it moves so fast that you cannot expect any regulator who is essentially a government bureaucrat to be able to efficiently regulate it. And so in a recent article, I talked about using self-regulating organizations, and I also proposed a technical standards organization. And if you think about it, that's the way in which the functions, right? So the internet, no one regulates the internet, but there is the W3C convention that keeps coming up with new standards that everyone then adopts. So think about a self-regulating organization similarly to say that, look, these are the things that we as service providers in this sector will bind ourselves to do. And then what's the role of regulation? And that's why I like the PDP bill a lot, because the PDP bill actually has a list of principles. And so what does the law and the lawmaker have to do? They just got to think at a principle level to say that, look, these are the principles that I think need to govern data technology from the context of privacy. Leave it to self-regulating organizations to then say, okay, let me translate these principles into the e-commerce sector or into the streaming media sector. And then, once there'll be many different SROs that come up with their suggestions, present those suggestions to the DPA, and the DPA will say, okay, look, this looks like it complies with the principles, let's do it. Because the DPA does not have the sector knowledge to be able to make those detailed regulations that this entity has. And the SRO does not have the legal authority to be able to make this binding. The way I think we can address this is let the SRO come up with the regulations just sort of in a draft form. Send it up to the DPA. The DPA will then say yes, this is okay, and approve it. So that way we can get the sector knowledge as well as the legal authority. I would say that is the way in which to regulate technology, so that we can do it quickly.
Shreya, you had a question on telecom.
Yes, sir. Good afternoon, Rahul sir. So my question was on the earlier discussion on the telecom industry. So with regard to the AGR dispute that was happening, and huge liabilities were imposed on Vodafone and Airtel and all of these companies. Do you think, sir, then that would have a great impact on the competition in that sector going forward, or not, or how do you think it will shape up in the future?
Yeah, look, I mean, that's a difficult one. So when Vodafone entered the country, I told you we did the Vodafone acquisition of Hutchison. We were asked a question, what does this AGR thing mean? It means everything is covered in the AGR. It's not just telecom services, it's everything else. And we told them, look, it is what it is. You can either get the law changed or you comply. And for various reasons, all the telcos chose not to comply. And so they just paid for the telecom side of it and didn't include the others. And as a result, for over 20 years, this has accumulated. So in many ways, this is something that they knew about. I mean, I think there was some belief that they would win the case, but as it happened, the Supreme Court wasn't sort of agreed with that view. If anything, the government could have withdrawn, because I think the government would have realized that, look, this is it's got to the point where it would completely bankrupt them to do it. So now what we've got a mechanism whereby it will be repaid over, I think, a 10-year period of time. We're relying on the just vast size of the Indian telecom sector, the fact that we've got this huge data opportunity, that eventually we'll make money and we'll make enough money to pay it off. And I guess that's sort of the only thing that will happen. I think we've had these sorts of shocks in the sector previously, and it hasn't killed the sector. So I don't think it will kill the sector.
But then, just a little follow-up, because Jio has also been massively funded right now. So I think my question was in that context, do you think the predatory pricing and all of these other strategies of Jio might also have an impact on that sector?
I mean, Jio is almost like the only horse in the race right now, given that they had to pay the least or completely negligible amount of AGR. So that's a risk whichever way you look at it. I think I don't know if predatory pricing is really going to be relevant, given that. So first of all, Jio's funding essentially wiped out their debt. So they had huge debt. What they've done is they've essentially wiped out their debt, and they've got a lot of very strong strategic alliances. But I don't think I don't think they ever lacked for money, and I don't think that they ever will lack for money. But still, they are unlikely to keep up predatory pricing forever. And I think no one builds a business on predatory pricing. Least of all the Ambanis who are actually really smart about their business. And also the other thing is that our prices are so low as it is, that how much lower are you going to get? Are they going to pay you to use their service? Because literally it's got to that point, right, where it is already so the benefits that you get are just so much. I mean, look, we all use Zoom or we use WhatsApp calling. We don't use the regular telecom network. Always think about it. That's sort of the reality of life, right? So
Inam, would you like to go next?
Yes, sir. Uh, it's an extremely an honor having witnessed you right now. Also, I just want to tell you that it was extremely, it's really fascinating. I was really fascinated to hear your telecom journey. Just want to understand, have you also advised these corporations on their companies facing human rights violations? My question stems from the fact of my experience for my third year of law school. I happened to read this book called Disconnect by Debra D. Lewis. She's an environmental scientist, and she's written extensively about how electromagnetic radiation has caused havoc in societies. So what this book basically specified was it spoke about these specific absorption rates which human can absorb. These electromagnetic radiations which humans can actually go on to absorb. And these specific absorption rates were actually like specified for the late 1990s, and that new specific absorption rates in the 4G era have not been mentioned at all, and how this can go on to lead to massive human rights violations in the near future. Also, I did try to actually pursue in the sense that by writing a letter to Apple, but they did not respond. I just wanted to like pursue it in the sense that uh, how individuals should know that that these specific booklets, these small booklets, within them they mention that how we're supposed to keep the phone 0.01 meters or 2 meters, 0.02 meters from our head and then speak. And that we do not get to know because we don't make an effort to actually read those specific details in those small booklets. So now I just want to understand as to how you have gone on to advise these corporations in.
yeah, so look, I mean, first of all, I'm not sure about these electromagnetic radiation, the impact of it, and I would. It's probably better to get some peer-reviewed scientific journals to tell us what the truth is on this, because for every theory which says that it is harmful, there are theories which say they're not harmful. There were theories when I was younger which said that using a microwave is harmful, and then people said no. Then someone said using the remote on your phone is harmful. Sorry, remote on your TV is harmful because that provides IR rays. Look, I don't know. And as a matter of fact, human beings are constantly bombarded with X-rays, all sorts of particles from outer space that make it through the ionosphere. I don't know. I mean, there's just so much out there on this that, to me, the way I think about it is, if there's a regulation, we must comply with the regulation. I would rely on scientists to come up with that regulation and then say, look, this is the regulation we need to impose. So, we've got green regulations on towers, and there is a certain specification in that regulation. All clients have to comply with that specification. When there is a new theory which says that this needs to be revised, until that gets reflected into the regulation, it is difficult for me as a non-scientist to be able to opine on whether, in fact, it is or not. So that's sort of the way I think about these sort of things, because otherwise, I would not be able to get out of my house for fear of catching corona, which is what I've done for the last 6 months. So,
Rahul, I wish I knew that there would be so many more questions, and in that event, I would not have spoken at all. But it's really a pleasure to hear you every time we have a conversation. I mean, I just end up learning a lot more than I knew before the conversation. And thank you so much for all the support that you have extended, and as a result of which, I think we have been able to bring together a set of very bright students who, during the course of the year, will engage with a lot of these questions that we spoke about very briefly during this 1 hour. And we also hope that at a trilegal level that there is a fair bit of support for this program that our fellows can get to work with some of you during the course of their year here. Thank you very much for being part of our advisory board, for being there, and for guiding us through this journey. And we hope we can
my
bring you.
pleasure, and all the best to all of you. This is a good cause. I think when Anant and I spoke about this in the beginning, I said please make this practical, because I spend too much time with students who've learned all the theory, and we need students who know the practice. It's so important to learn that side of it. So I'm glad that he's reaching out to people like me to talk about the practical journey, as opposed to come and tell you about all the cases that have been fought on this, which you can learn in any law program.
Thanks, Rahul. Thank you very much.
My pleasure. Thank you.
Thank you, Rahul, sir.
Thank you, sir.
Thank you, sir.